Do I still? I do. Still doing the headphones because it's just not. It's worth looking like a 1980s DJ if you with the big head, I guess, if you know you're recording with sound. So we'll see how that goes for the time being. Hello again, this is Ben Hitchcock Cross talking to you today. I am going to briefly explain what is going on in these deposition videos here. Remember, deposition is an extension of the court, but it is not a courtroom setting. And the main distinctions are this. There's not a judge available to rule on whether evidence is admissible. And so for that reason, the deponent, the person answering the question, is just expected to answer no matter what. And then you're supposed to figure it out ultimately on the back end. There's sometimes when it's considered too much and you don't have to respond to that question, okay? That privilege is automatic, okay? And it's never okay. You can't undo a privilege leak because it's, let's say, adversarial information. It's protected. I can't unhear privileged information. So for that reason, more than anything else, I have a duty not to hear privileged information. Meaning if I think somebody's got it, I got to tell them not to give it to me. If I think I get something that's privileged, I got to not use it. I got to alert the other side. I got to take positive steps here not to learn their secret plans. Let's say I'm at a deposition. They're in the hallway chit-chatting. I've got a positive duty not to go and eavesdrop on them. Okay? There's good manners, but there's an ethical duty as well. So that we're just focusing on the ethical duty there. You don't do that. Same thing on my end. Let's say they leave. I don't go snooping through their papers. I don't, because it's a deposition. I'm saying there's access that you guys have, that the attorneys have to each other that you don't normally have. In that situation, there's a line there that you got to be careful of. Okay. So, but again, you have a big, there's no judge there. So, and you've got two attorneys who have their own opinions on what the law is. And they're really the only way to get through that, if there's a disagreement, it was with good manners and flexibility and trying to get as much on the record and solved in good faith as ahead of time. That's how you do it. So I just want to say that to the extent that, we'll look at here, there's a big question that came up. So Mr. Reardon at the beginning of the Marva Herndon recording makes a series of standing objections about should outside people be in there? Should inside people, should that be allowed? Should the videographer be allowed like that? Okay. He has every right to put that on the record. And he has every right to be totally wrong or totally right about that subject. Absolutely. I have the absolute right to be opposed to that. Okay? Now, I'm not going to get into the legal argumentation of why I think he's right or why I think he's wrong, because it's probably pending. But the whole point is that as an attorney, we need to preserve the record, preserve what we have. But you're also taking a risk if you're saying, I'm not going to do X, Y, and Z, or this is going to happen, or whatever, because you can be held to account as an officer of the court to the tribunal or whatever's going on, right? There can be sanctions against you for misbehavior. So let's be clear that the law, and in some states, for example, I read this in Texas, way better law, way clearer, way better, easier to understand of what's going on in the actual law and the statutes itself. For example, it will say depositions going on, it continues, and the guy has to answer the question unless there's an objection about harassment, privilege, and three other things, or two other things, okay? Ours just says privilege, but it's clear that and it's actually not that clear. What there is here in the state of Wisconsin is a district court decision by a well-respected district court judge. That means a federal judge explaining basically what should happen. And that carries about zero real authority, but a lot of persuasive authority. And otherwise, there's some case law that says that you have to have a bona fide reason and a good faith contention for walking out, or not walking out, but refusing to answer. And other than that, it's not very clear about what you can do and what you can't do. I wish I could say that, okay? So let's just focus, though, in on, so again, in that situation, a lawyer takes a lot of risk in doing something that they supposedly can't do, but it's not clear. On the other hand, I want to tell you that there is such a thing as Wisconsin nice, and there's a lot of normative persuasion against people who are on the receiving end of that kind of bad behavior, bullying behavior, for example, to just sort of take it because, you know, this is Wisconsin and a pushback isn't really nice. So that's another issue of what you need to keep in mind. But hey, I just want to encapsulate the headline. I guess I should have put this in front. In a deposition, there's really nothing keeping anybody from committing misconduct because there's no instantaneously. It's a much more delayed reaction. So keep that in mind. But again, if I say, hey, your client is harassing me, I've got to go out and file a motion for protective order. It's not clear when I have to do that. There really is not very good guidelines in the state of Wisconsin for what is supposed to happen and what's not supposed to happen. That's my opinion. I've read all about it. I'm not afraid of, saying I think that Wisconsin needs to do better on that. I think the Texas laws are way better than the Wisconsin ones. It also, by the way, says in the Texas rule, there's only ways to properly object are to say objection form, objection foundation, objection hearsay, objection privilege. And then you don't do speaking objections. That's in the law in Texas. That's pretty good. Wisconsin used to be on the forefront, but we've got some work to do now. Got an opportunity. So, got to wrap things up. Got to go to on the rest of my Saturday there. But that's, and I guess I wanted just one more thing, if I can say. In my opinion, the claim, and we'll find out what happens, that you can't discuss something that happened in a closed session meeting because it's closed, because of public records, or because an attorney was in that meeting is totally wrong. Everybody knows it's wrong, and I assume the opposing counsel knows that it's wrong too. Okay? We're just going to assume that that's the case. Could be wrong. I don't know. That if that were the case, and the law was very clear on that, then to refuse to answer, to direct somebody, and that's the dangerous thing there, is to direct somebody to refuse to answer and then have them refuse to answer a question on, say, public record, on what happened behind closed sessions based on something that's not privilege, harassment, or one of those things, is something that attorney and everybody, all the attorneys know. You've got to just let them answer the question. You can't sit there and tell them, I'm going to have them refuse to do it unless you've got those grounds there. So I want to be clear on one other thing. The opinion by the district court judge says if the opposing counsel says, ask the opponent something totally harassing, and I think that the one in there is, are you homosexual? But it may be 10 years old. I don't know. Okay? That case clearly says that the opposing counsel is perfectly within their rights to shut everything down and walk out, because that question should never have been asked in the first place. You see how there's a lot of gray area and a lot of problem. And if you do walk out, though, you could have a problem because there's a case that says that. But the other person could have a problem, and it starts to get into a game of chicken. Because it all boils down to who's going to go to the judge and what's the judge actually going to do. That's where we're at. All right? So I hope that answers your question of why is this so contentious, what's going on there, and why does Ben feel free to sort of ignore what Chris says. And it's because what Chris says isn't the rule, that's just his opinion. And we'll have to figure that out later. So that's my answer on deposition stuff. Stick with us. We'll keep you informed.